My name is Ruslan Kosarenko. I'm an immigration lawyer, and I was going to speak about asylum, humanitarian protection, some family migration, human rights issues, and also about options for graduates. I think everybody knows what asylum is. If a person is being persecuted in the country of origin for the reason of race, religion, nationality, political opinion, or anything else, that includes gender identity, sexual orientation, that person can ask for asylum in any country which signed the Geneva Convention, including the UK. At the moment, there are 77,000 applications outstanding in the Home Office. It's an organization which considers asylum applications from people who arrive at ports or people who wish to stay in the UK whose visa expired, or people who come here illegally and at some point in their time wish to claim asylum. So this is the current figure. You can see the breakdown what this figure consists of. 77,000 is total work in progress. 20,000 people are waiting for the decision. 3,000 are waiting for post-decision action. Asylum appeals outstanding, 12,000. And about 27,000 people are identified as subject to removal action. 12,000 are on hold, and also there are 3,000 further leave application outstanding. So you can see the volume of these cases, and you can see that a lot of these cases, a lot of these decisions are being appealed, and this is what my firm does. We make initial applications for a person, and if that application is refused, we'll normally appeal in the first-tier tribunal. My firm deals with asylum applications mainly from Russian-speaking countries. We have done high-profile applications, including applications which I dealt with Julian. We dealt with applications from former deputy minister from Russia, and less high-profile cases from Belarus, for example. I did a lot of cases from Uzbekistan, Georgia, and unfortunately we now are experiencing a huge surge in applications from Ukraine. And there is a recent case law which Julian identified. On the 7th of March there is a new country guidance from the upper tribunal about Ukrainian asylum seekers. That's in relation to people who avoid mobilization or going to the army in Ukraine. And the upper tribunal judges found that there is no risk for such people to return to Ukraine, because if evading military service, although is punishable by Ukrainian law, but in practice that's not implemented. So there is a very little risk that the person will actually go to prison for that. However, the judges found that there may be a violation of Article 3 of European Convention of Human Rights if that person is detained on arrival in Ukraine and questioned. And that can violate person's Article 3 right, because there is a real risk that the person may be tortured in CISO. Those who are from Russia or Ukraine here will understand what CISO means. That's a pre-trial detention. So, if you are interested, you can have a look at that case. It's in the tribunal database of cases. It's a reported decision. It's a very fresh one. It comes first now on that database, so you can't miss it. I mentioned Article 3, and you may be wondering what is the difference between asylum and Article 3 claim. Article 3 is an article of European Convention of Human Rights. So what happened in this particular case I was describing, the asylum was not granted. It means that the person was not recognized as a refugee in accordance with the Geneva Convention, but the person's appeal was allowed on the basis of potential breach of Article 3 of human rights. That means that the person will get a different type of document, will probably not be entitled to a convention travel document. It's also a status in the UK, but it's a lesser degree of protection, if we can say that. There are other human rights related applications, not just Article 3. we deal with a lot of Article 8 applications. Those applications deal with private life, family life. Private life is when a person, for example, has lived in the UK for a very long time, typically more than 10 years, and normally would have lost ties in the country of origin, or there are some circumstances which don't allow that person to return to that country. Also, Article 8 covers situations when there are children born in the UK that person has. Sometimes those children will already be British citizens because they lived here for 10 years or more, or those children cannot be removed because they lived here for 7 years or more, and they go to school here, and it would be unreasonable for their child to return to the country where they've never been. Sometimes they have partners here, sometimes they will have elderly relatives they're looking after here. So there will be lots of circumstances when Article 8 may potentially be invoked. But my examples about family and children cover more family life rather than private life. Although sometimes the situation may not be as clear. Sometimes the Home Office regards family life between two, for example, partners, unmarried partners, as private life. Whereas if you are married and have a British child, then they will classify it as family. There are other articles which may be relevant in immigration contexts. That's Article 2, if there is a risk that you may be killed in the country of origin. Article 3, we've discussed the risk of torture. Article 8, I've told you about. Article 10 can also be used in your application for protection. That is, if you can't express your political opinion freely in the country of origin. And of course, one of the reasons why we're here today is to offer you an opportunity to be an intern in our firm. And if you have any visa issues in that regard, our firm is a sponsor for Tier 2, and we also sponsor Tier 5 applications for internship. If you want to remain in the UK after studies and get experience, we can provide you with sponsorship. And then if we decide to continue working with you, we can sponsor you on the Tier 2 program, and this way you can qualify either as an immigration lawyer or a UK citizen. That's all for me.